Judgment in the appeals, the Queen on the application of Mirza, Iqbal and Ehsan, and the Secretary of State for the Home Department.
Lord Carnworth will explain the decision of the court.
Section 3C of the Immigration Act 1971 extends a person's leave to remain pending determination of an application to vary the period of leave, so long as the application is made before the original leave has expired. Without such an extension, overstaying is unlawful, and this has adverse consequences in relation to future applications for leave to remain. All three appeals before us raise the issue of how Section 3C applies where an application is made in time, but for some reason is procedurally defective. In two cases, the defect was failure to pay the correct fee at the time of the application. In the third, it was failure to make an appointment to provide certain biometric information required by the regulations. The relevant regulations indicated that an application which did not comply with these procedural requirements was to be treated as invalid. On these grounds, the Secretary of State held that Section 3C had no application and that the leave to remain pending determination was not so extended. This decision was upheld by the Court of Appeal. The Supreme Court unanimously dismisses the appeal. The single judgment is given by myself, with which the other justices agree. The Court notes that the Secretary of State's interpretation of the relevant provisions has not been consistent. It agrees with the Court of Appeal on the potential for unfairness and on the need for rationalisation. However, there being no challenge to the legality of the relevant provisions as such, they must be construed in accordance with the ordinary principles of statutory interpretation, starting from the natural meaning of the words in their context. The regulation provided that if an application is not accompanied by the specified fee, it is not, quote, validly made. An application not validly made can have no substantive effect and thus cannot trigger the relevant section. The Court of Appeal was correct in that conclusion. The Court was also correct to dismiss a separate ground of appeal by Mr. Iqbal based on alleged unfairness. He said that he should have been warned of the problem in time for him to be able to correct it. However, although it is unfortunate that he was caught out by a change in the level of fees, there had been no failure by the Secretary of State to publicise that change. The problem arose because his application had been made very close to the expiry of leave. In the third case, the failure to apply for biometric information should not be treated as retrospectively invalidating the application from the outset. The natural reading of the relevant provision is to give power to invalidate the application from the time of the failure. However, that would not help the appellant because even if her leave had continued until the date of the Secretary of State's decision in March 2012, it would not have assisted her in respect of her new application made after that date. Accordingly, the appeals are dismissed.
Thank you.